Are you tired of hearing that the only way to get the compensation you deserve from the VA is to start a brand new, painful claim from scratch? It's a common misconception, and frankly, it's exhausting. Many veterans are sitting on claims that are rated too low, or they have conditions that have worsened over time, yet they dread the thought of re-entering the bureaucratic nightmare of a full refile. The truth is, you often don't have to. There are powerful, legal, and often faster pathways within the VA system designed specifically to increase your benefits without the complexity and risk associated with filing a completely new primary claim. We're not talking about anything shady or unethical here. This is about leveraging the rules and regulations the VA already has in place. We're going to walk through 7 distinct strategies that high-level VA advocates and experts use to maximize a veteran's monthly compensation and secure a higher rating, often using evidence you already possess. If you're currently rated at 70%, 80%, or even 90% and feel stuck, pay close attention. This information could fundamentally change your financial future. The first and most straightforward path is leveraging the HIC, claim for increased PAW, on an existing service-connected condition. This is where most veterans start, but they often approach it incorrectly, which leads to denials. A claim for increase is not a new claim. It's simply telling the VA that the condition they already recognize has deteriorated. The key mistake veterans make here is submitting old evidence. If your anxiety was rated at 30% 5 years ago, simply stating it's worse now isn't enough. You must provide clear, concise, and recent medical evidence that demonstrates the current severity meets the criteria for the next higher scheduler rating. This means focusing on the frequency, severity, and duration of symptoms, and crucially, the resulting occupational and social impairment. For mental health, this means showing how often you are unable to leave the house, how frequently you have panic attacks, or how consistently you are unable to maintain employment or relationships. The VA rates based on a schedule, and you need to hit the specific diagnostic criteria for the 50%, 70%, or 100% threshold. You must be proactive in getting new doctor's notes that specifically use language reflecting the higher rating criteria. Don't just ask your doctor to say it's worse. Ask them to document the specific symptoms that align with the VA's rating schedule. This focused approach minimizes the VA's ability to deny based on lack of evidence and keeps the claim targeted and moving quickly through the system. Now, what if your service-connected condition is stable, but it's causing other health problems? This brings us to the second and perhaps most overlooked strategy for increasing benefits: secondary service connection. This is a massive area of opportunity that many veterans miss because they focus only on the direct injury from service. A secondary claim links a non-service-connected condition to one that is service-connected. Think of it as a domino effect. For example, if you are service-connected for a severe lower back injury and that injury causes you to walk differently, leading to chronic knee pain or hip issues, the knee and hip problems can be claimed secondarily. The back pain caused the gait change, and the gait change caused the knee damage. Similarly, severe chronic pain can lead to depression, or medications taken for a service-connected condition can cause gastrointestinal issues or erectile dysfunction. These secondary conditions are rated in addition to the primary condition, significantly boosting your overall combined rating without ever having to reprove the original service connection. The absolute requirement here is a strong, definitive medical nexus opinion. You need a doctor to explicitly state that, based on medical literature and your records, Condition B is at least as likely as not caused by or aggravated by service-connected Condition A. Without that strong nexus statement, the claim will likely fail. This isn't just about adding a few points. A successful secondary claim can easily push a veteran from a 70% combined rating straight into the 90% or 100% bracket. Moving into the realm of financial security, the third critical pathway is securing total disability based on individual unemployability, or TDIU, CHEREG. This is the pathway to 100% compensation, the highest monthly rate, even if your combined scheduler rating is less than 100%. TDIU is designed for veterans whose service-connected disabilities prevent them from maintaining substantially gainful employment. The legal threshold for applying is typically a combined rating of 70% or higher, with at least one condition rated at 40% or higher, or a single service-connected disability rated at 60% or more. The beauty of TDIU is that you are not arguing about symptoms as much as you are arguing about occupational impairment. The question is simple: can you hold a job? If your service-connected anxiety, back pain, or migraines mean you cannot maintain employment consistently, even if your rating is 80%, you are entitled to TDIU, which pays at the 100% rate. To win this, you need to provide compelling evidence of your work history, including periods of unemployment, jobs you attempted and failed, and statements from employers or family members detailing why you had to leave or could not perform your duties. Crucially, the VA looks for evidence of marginal employment, work that pays less than the federal poverty line. If you are working but earning very little due to your disabilities, you may still qualify. TDIU is a game changer because it bypasses the often difficult requirement of hitting the 100% scheduler number, providing full financial protection based on your inability to work. Beyond the standard scheduler ratings, there are often hidden financial bonuses available through Special Monthly Compensation, or SMC. This is our fourth powerful strategy, and it represents tax-free compensation paid in addition to your standard disability payments. SMC is complex because it's based not just on the rating percentage, but on the functional loss and specific anatomical losses you have experienced. SMC categories range from SMCK for loss of use of a creative organ to the highest levels like SMCR2, requiring continuous aid and attendance. The most common SMC category veterans overlook is the housebound rate, often referred to as SMCS. If you have a 100% rating or a combined rating of 60% or more, and you are permanently and substantially confined to your home or to a specific ward or hospital due to your service-connected conditions, you qualify for this significantly higher monthly benefit. This includes veterans who can only leave the house for medical appointments. SMC is not automatically granted. It must be claimed, often by filing VA Form 21-2 680, Examination for Housebound Status. You need detailed medical evidence confirming the severe functional limitation and confinement. Furthermore, if you require daily assistance for basic needs, bathing, dressing, feeding, due to your service-connected disabilities, you could qualify for SMC aid and attendance, which is a substantial boost. Never assume the VA will automatically assess you for SMC. You must explicitly file for it when your functional limitations warrant it. Now let's pivot from maximizing the current claim to challenging past decisions. Our fifth strategy involves the rarely successful but incredibly powerful clear and unmistakable error, or Q claim, Jim. A Q claim argues that a previous VA decision, which has already become final, was based on a significant legal or factual error that was so obvious that it would have changed the outcome had it been recognized at the time. This is not the same as disagreeing with the medical evidence or the severity of the symptoms. It must be a procedural or regulatory error. For example, if the VA failed to apply a specific regulation that was in effect at the time of the decision, or if they ignored material evidence that was properly submitted and relevant, that could constitute a CUE. The standard for CUE is astronomically high, but if successful, the VA must retroactively correct the error, often leading to years of retroactive pay and a higher current rating. The key benefit? You are not refiling, you are correcting a historical injustice. This requires deep regulatory knowledge and is often best handled by accredited agents or attorneys who specialize in identifying these specific legal pitfalls in old VA decisions. Do not attempt a Q claim unless you have concrete evidence of a specific identifiable regulatory error. When a decision has recently been made, perhaps you filed an increased claim and were denied, the modern appeals process offers two fast-track options that circumvent the need for a full refile. This is our sixth strategy, utilizing the Hoogsteenamarad Higher Level Review HLR, and Supplemental Claim Behandelbij pathways under the Appeals Modernization Act, AMA. If you receive a decision and simply disagree with how the VA interpreted the evidence, the higher level review is your fastest route. You are not allowed to submit new evidence here. Instead, you are asking a senior, more experienced VA reviewer to look at the exact same evidence the original decision-maker had and determine if they made a mistake in applying the law or regulations. This process is typically much faster than a traditional appeal and is excellent for correcting simple errors or misinterpretations. Conversely, if you believe the VA was right to deny you based on the evidence they had, but you now have new, relevant evidence, like a new doctor's report, a new nexus letter, or new buddy statements, you should file a supplemental claim. The supplemental claim allows you to reopen the case and submit the new information, effectively continuing the original claim without starting over. Both HLR and supplemental claims are essential tools for veterans who have recently faced a denial but do not want to go through the lengthy process of a new claim and risk losing the original effective date. Finally, while not a direct increase in the veteran's disability payment, our seventh strategy focuses on maximizing ancillary benefits and dependent claims, which provide a significant boost to the overall household financial health. Many veterans forget that a higher rating unlocks numerous non-monetary benefits that dramatically reduce household expenses. For veterans rated 100%, either scheduler or TDIU, the entire family often becomes eligible for comprehensive benefits. This includes Chapter 35, Dependent Education Assistance, DEA, for spouses and children, which pays for college tuition and related costs. It also includes Farm Champion via Healthcare, for dependents, which acts as a robust secondary health insurance, saving thousands in premiums and out-of-pocket medical costs. Furthermore, if the veteran has dependents, a spouse, children under 18, or children over 18 but still in school, adding them to the existing award is a simple administrative process that provides a noticeable increase in the monthly check. This is not a refiling. It is simply updating your family status. Ensure that if your family situation changes, marriage, birth of a child starting college, you immediately notify the VA. Leveraging these ancillary benefits effectively means that even if your monthly disability check doesn't increase substantially, your overall disposable income and financial stability improve dramatically because major expenses like health care and education are covered. The path to maximizing your VA benefits is rarely about starting over. It is about being strategic, targeted, and knowledgeable about the specific legal mechanisms available to you. You must stop thinking of the VA process as a single, monolithic wall and start seeing it as a series of distinct doors. Whether you are filing a focused claim for increase, linking a secondary condition, utilizing TDIU to achieve 100% pay, claiming SMC for severe functional loss, correcting historical errors with a CUE claim, or using the AMA lanes to quickly appeal AIC recent denial, the goal is the same: leverage the existing framework. The most successful veterans are those who meticulously document their worsening symptoms, secure strong medical nexus opinions that connect the dots between conditions, and proactively claim every benefit they are legally entitled to, including those crucial ancillary benefits that secure their family's future. Don't let the fear of refiling stop you from pursuing the compensation you earned. Take action today, but take the right action, the focused, legal action that uses the VA's own rules against the inertia of the system. Your higher rating is waiting. You just need to know which door to open.